Well, good morning, everybody, and thank you very much for joining us. And thanks to all of you also who submitted questions in advance. We'll come to the questions at the end. I'm Paula James. I'm a partner in Irwin Mitchell's Will, Trust and Estate Disputes team. And this April, we have seen a rise of 450% in the number of clients contacting us for help with a new will or for a review of their existing arrangements. No doubt for many, it's the COVID-19 threat which has made us all fear serious illness. But also I think that many clients have found a few extra hours in their days and have taken that time to think about planning for the future and what they would like to happen in the event of their death. This morning, I'm joined by Emily Wentworth, who's a solicitor in Irwin Mitchell's Tax, Trust and Estate team, and Yusafa Hazara, who is an associate solicitor specialising in the international elements of tax, trust and estate, and also by Stuart Stretton-Hill, who specialises in later life planning. We'll be sharing with you some of the questions that have been raised with us over the last few weeks in relation to the preparation and the execution of wills and of lasting powers of attorneys also. If you want to ask a question, you can use the buttons that are at the bottom of your screen, and we'll take the questions at the end. We are recording the webinar, and we'll send out a link of the recording after the event. And finally, if we do hit any technical issues during the event, we will cancel it and we'll send out a recording so that you don't miss out. So, with no further ado, we'll move to our first and most common question asked. And Emily, if I could, I'll direct this to you. Just, is it possible to make a valid will at this time?
Thank you, Paula. The short answer is yes, it is possible to make a will and execute it safely and legally. And this is something we're helping clients with at the moment. 2 points where we are making adjustments. Usually we'd speak to clients and meet with clients face to face. Obviously that can't happen. And so we're making use of video and telephone facilities and email so that we can get instructions and liaise with them in that way. The second area of concern is obviously the actual signing of the will. Now, in order for a will to be valid, it has to be signed by the person making it in the presence of 2 witnesses at the same time. Obviously, given the current restrictions in place, that may well not be possible for some. Some people are self-isolating as well with people that they wish to benefit. Now, just a warning sign here, if you are looking to get a will signed, it shouldn't be with anyone who is mentioned in the will. They can't witness it because it would invalidate the gift under the will. And so it's basically finding willing witnesses in a safe way to get the will validly executed.
Thank you. Thank you very much, Emily. Do you think, and this many people have asked this question, do you think that a will be valid if a neighbour witnesses it through a window?
Yes, so this is one option being discussed at the moment. So what this would be is the person making the will on one side of the window and the witnesses on the other side. The will is signed on one side, passed through the letterbox and signed by the witnesses. Now, there are health risks with this. The virus can survive on paper up to 12 hours. And so the act of handing the paper through the letterbox may cause unwanted exposure, so definitely something to consider. Now, the question of validity of this way of signing, not having the witnesses in the same room as the person signing the will could cause some question over validity, but there is old case law back from 1781 that says that provided the witnesses have line of sight of the person signing the will, then this will be sufficient. What we're currently doing is we are sending our wills to our clients with detailed guidance how to sign their will effectively and asking them to make their own arrangements. It will obviously depend upon their circumstances, who they're isolating with, and how comfortable they are with the exposure and how to do it safely. There is currently a question over video conferencing to witness wills. This is where the testator, the person signing the will, and the witnesses are on the other side of a video conference. And the witnesses watch the testator sign the will, and then the will gets posted to the witnesses to then sign. Now, this is not currently valid under English law. There are other countries who are passing legislation to allow this and relaxing the rules on will execution, but this is not currently law in England. So essentially, each case will turn on its back. It will depend on your circumstances, what you feel comfortable doing, but it is certainly possible to get a will signed in the current climate.
So I think, Emily, the short answer is that we can help you find a way to make a will that is safe and that complies with the current laws on will making.
Absolutely.
And some of the inquiries we have been receiving are from people who've never considered making a will before, and they're asking us, am I too young to make a will, or I don't have any assets to leave to anyone, so do I still need a will? Emily, can you help us with that one?
I certainly can, Paula. Global pandemic or not, anyone who's over the age of 18 with mental capacity should make a will. A will allows you to direct not only who should benefit from your estate, but also who should look after any minor children that you have as well by way of appointment of guardians. It can be updated as many times as necessary. Some people are under the impression once you make a will, that's it for life. It's not. Obviously, making a will is important to take your circumstances into consideration at the time you make it. Circumstances change, life changes. So it's just a case of keeping that up to date. So it might be that currently you don't have children, and so you'd like to make provision for your family members, your friends for now. But if you do later have children, then you can certainly update that and make those provisions. Obviously, some of our clients make wills when their children are quite young. And once their children get older, they consider them more sensible, more able to act as executor of the will as well. So that can certainly be updated. And then grandchildren come along. So provision for them as well, if that's what the client wants. Other reasons to make a will: inheritance tax planning, funeral wishes. So you can say whether you'd like burial or cremation, or go as far as to say which songs you'd like played. Provisions for blended families, second marriages, ensuring that children are appropriately provided for. And on the point of people that don't think they have any assets, some assets are forgotten, such as post-death benefits, life assurance policies, and pension payments. So even though you might not consider that you might need a will, it might well be necessary for you. Sorry, Paula, I think you're still on mute.
Thank you, Emily. I certainly was. I knew that I would do that. What I was saying was that Emily's quite right. It is really also important to review your expression of wishes that is probably attached to your life policies, pensions, and any death in service benefits, to ensure that the beneficiaries you named years ago when you actually became entitled to those benefits are still right for you now in the current circumstances. Often, you just fill it in and express a wish that your spouse benefits, but you might want to add alternative beneficiaries should your spouse predecease you, or you know, in the event of divorce or family breakdown, separation, it might not be appropriate to have the same beneficiaries as you had the years ago when you entered into the agreement. Stuart, this next question is a question for you, I think. What if someone is very ill or has dementia and they want to make a will?
Yes, a good question there, Paula, and one actually we come across whether there's a pandemic or not. The key question is whether the individual's actually got the relevant mental capacity, the relevant testamentary capacity to make a will. There's stringent tests that have grown up over many, many years as to the test of capacity to be able to make a will. Essentially, the individual needs to be able to understand what a will is, what its effect is, and what property they're giving away. The problem is if someone's ill or they're living with dementia, they may not pass aspects of that test if they can't understand what information they need to be able to form the decision to make a will, or if they can't retain that information long enough, which is obviously a particular problem with dementia, and whether they can't weigh that information in order to reach the decision. It's important that they have testamentary capacity at the time they decide to make a will, so the time they're providing instructions to us. But they also need to have capacity at the time that they sign the will as well, which is clearly an issue of someone's capacity declining quite quickly. What we would normally do in the normal course of events is meet with the individual, take their instructions and form a view on their capacity at the time we meet with them. And then we'll meet with them again when it's time to sign the will and again form a view on their capacity at that stage. If we've got any doubt of their capacity, then that can call into question the validity of the will at a later date, which could give rise to claims against the testator's estate. So what we would do there is to instruct a medical professional to provide a report and or act as a witness to the will in order to emphasise that the individual does have capacity. The problem is if there is doubt over capacity, it presents significant difficulties in this time of social isolation and distancing. Frankly, when assessing capacity, there's no substitute to meeting the individual personally, and it may not be possible to properly assess capacity over the phone or over a video conference. I mean, you don't know if someone's behind them, perhaps feeding them answers or prompting them to give the appropriate response. Additionally, in terms of instructing medical experts, medical professionals are obviously overburdened at the moment and may be unable or unwilling to provide an assessment or just can't do so in a timely manner. So where we do have doubts, where we are satisfied that someone doesn't have capacity, it is possible for someone to apply to the Court of Protection to make a will on behalf of the individual who lacks capacity, which is known as a statutory will. That's usually done by the individual's attorney or their court-appointed deputy, but technically it can be done by anyone, but provided they have permission of the court to bring the application. The statutory will is basically made on behalf of the person who lacks capacity, and it has to be approved by the court. Importantly, the contents of the will or the structure of the will must be in the individual's best interest, which is not the same thing as asking what would they have done if they had capacity. So it's a matter of weighing up all the pros and cons of the particular will that you want to put in place. It is a costly procedure. It is an involved procedure. You need to put lots of evidence to the court. You need to submit to the court evidence of lack of capacity. You need to serve other individuals, so potential beneficiaries under a current will or under intestacy. You need to be served with the details of the application in case they want to object. You also need to serve details of the application on the individual themselves personally and try to explain to them as far as possible why the application is needed and what the effect is. You need to provide a report on the individual's financial position, analysis of the inheritance tax position, and a statement setting out why the particular will is in their best interest. So, as I say, very, very involved in terms of the information you need to put to the court. Additionally, an independent body, the official solicitor, is usually appointed to act for the individual to ensure that the will being proposed is in their best interest. The problem with it can obviously turn contentious if potential beneficiaries object to the contents of the will. It takes a long time usually. Rough timescales before this crisis would be in sort of 6 to 12 months for a will that wasn't contested. That said, the court can deal and continues to deal with applications urgently if the individual is nearing the end of their life. And those applications, certainly prior to the pandemic, could be turned around within about 48 hours. But obviously there are current delays. So, I mean, there are lots of additional issues caused by COVID. Initially, how do we obtain a medical report that will satisfy the court? How does the medic do that assessment? Can it be done over video conference? How do you serve personally on the self-isolating individual if they're elderly or they're vulnerable or they're in a care home? That can prove very, very difficult. The current guidance from the Vice President of the Court of Protection is that visits to care homes to the individual are strongly discouraged, but it is recognised this could prejudice the litigation. Service on other parties, there's obviously delays with the Postal Service, so that could put the court deadlines, court timetable at risk. There's delays at the Court of Protection as well. They have issued guidance saying property and affairs applications, which include statutory wills, are now low priority compared to health and welfare applications, unless the individual is nearing the end of their life. And availability of staff at the official solicitor, obviously they have people who are isolating as well, so it will take longer for the official solicitor to provide responses to applications. In summary, yes, someone who is ill, who is living with dementia, can make a will, provided they've got capacity, and it's very important to accurately record that assessment of their capacity in case it's called into question later. If they don't have capacity, an application to Court of Protection for a statutory will be required.
Thank you, Stuart. So there's some challenges there in the current circumstances, but all is still possible and, if necessary, can be expedited if there's real urgency there. Thank you, Stuart. Another question that we have received frequently is, clearly the situation in the world is changing very quickly. We're entering into a global financial crisis, and we are being asked to review our clients' wills because the value of their assets has changed, which can lead to unfairness for the beneficiaries. So there are many reasons why a will could become out of date, and this is why obviously it should be reviewed. But there are some obvious pointers in the current crisis. Emily, can I turn to you?
Paula, I lost you slightly on that last bit, but I can certainly explain why the reasons why people should keep their will under review and why it's so important at the current time. Well, certainly family breakdown and separation. The circumstances may well not be in place at the time, as I said before, that you made your will, and so things might have changed. Marriages may have broken down. You might have got married, and marriage revokes the will. So it's definitely something to keep reviewing on a regular basis. Death of a beneficiary is another main one. Now, a lot of people do think they know what will happen if someone passes away, and they've mentioned them in their will. Unfortunately, it really depends upon the reading of the will and what provisions have been made, what substitute provisions have been made within it. And so it might not be as straightforward as you might on first reading think. The vulnerability or additional need of a beneficiary, particularly when you've made your will, when you've had young children, your children have got older and potentially have grown to be a bit more vulnerable, need a bit more help, and potentially that might change how you would like to leave your estate and the distribution of it. And as you said, change in ownership and value of assets. Some things might have gone up in value. commonly sales of houses. Values aren't constant, as we've clearly seen recently, and values can change drastically in a short space of time. You've also got the consideration of inheritance tax payments. Where's the inheritance tax coming from, if there's inheritance tax chargeable? And debt. So if the value of the property has come down, what does that mean for the payment of mortgages or debts on your estate? So lots of reasons why you should be keeping your will under review. Every sort of year or so, just have a quick review just to check things are still relevant for you and relevant for your estate.
Thank you, Emily. And certainly, from my perspective as a will dispute practitioner, out-of-date wills are one of our major causes of arguments, disputes, unhappiness, and it really can destroy a family. So it is very, very important to make sure that your wills are kept up to date. Moving on to our next question, I'm going to direct this to Yusafa, if I may. Many of our clients have assets and obviously properties abroad, and they are asking us whether their English will can deal with those properties, or whether there are alternative ways to plan for their succession of assets abroad.
Thanks, Paula. Good morning, everyone. I hope you're all well. So firstly, in response to your question, there is no one answer for this, and the planning options very much depend on the person's domicile status. So this is quite a complex concept in itself, but generally domicile is where the place where the individual regards as their permanent home under English law. It also depends on their personal circumstances and the location of the asset. So generally with our clients, we say it's best to take it on a case-by-case analysis. But broadly speaking, it is possible to have an English will that applies to worldwide assets, and this could include properties abroad, such as holiday homes, bank accounts, investments, cash in the bank, etc. The issue here is that the particular foreign jurisdiction may not recognize the legal validity of an English will. So this is particularly common if the English will contains a trust, which some foreign jurisdictions might not recognize. So there could be complications there. If the foreign jurisdiction fails to recognize the will, this could lead to what's called forced heirship rules applying, and the rules for forced heirship varies from country to country. But in essence, where forced heirship rules apply, it means an individual cannot freely dispose of the assets as they see fit. But through careful planning, in some cases, forced heirship rules can be avoided. For example, the EU succession regulation has been quite helpful in assisting clients to have connections with the EU to be able to elect for English law to apply in their will. So there are ways to get around it, but it needs a case-by-case analysis. And for a non-domiciled client with assets in the UK, often the question we get asked is whether a foreign will can be admitted to probate in England and Wales. So the answer to that is yes. So if your will is executed in accordance with the usual rules, which Emily explained, in that it has to be signed by the person making the will and witnessed, etc. So that would be valid. But during COVID times and the crisis that we find ourselves in, clients might want to wish to rely on their foreign wills, which, as I mentioned above, they can be executed in accordance with the laws of the country in which they're executed, or the place where the testator is domiciled, or habitually resident, which is another concept that needs looking into, or if they're a national at the time of execution of that country. So there are ways to get around it, but it needs a case-by-case analysis.
And what about our clients who are in lockdown abroad, Yusafa?
Yes, so there has been a lot of talk about ensuring that wills are correctly executed so that they're valid. So for testators with a connection outside of England, there are alternatives. And again, this is all very much dependent on their circumstances. For example, in some cases, for the will to be valid in England, So as I already mentioned, it's enough that it's valid under the law of the jurisdiction in which it's been signed. As an example, in some civil law jurisdictions such as France, they recognize handwritten wills, which is signed by the testator without the witness. The clients finding themselves in, situations, if they're in France, can rely on that. Another example, in Scotland, they only require a single witness who can also be a beneficiary under the will. So again, depending on where the assets are located, the rules of that particular jurisdiction can be used to give flexibility to clients stuck abroad, and they could make use of the less rigid or prescriptive local laws, which could apply to will signing.
There's some very useful information there. Thank you very much, Lusata. Now, again, I know from experience as a dispute practitioner that family businesses are a rich source of post-death disputes, often because a great deal of the family wealth is tied up in the business and the involvement or management of the business is not spread evenly across the family. So there's often a perceived unfairness on the death of the founder of the business. We're being asked also about what would happen if a business partner or a shareholder, major shareholder, dies, and how the management and ownership of the business would be going forward. I wonder, Emily, if you could help with that question.
Thank you, Paula. Yes, I can. It really depends on the existing agreements that are in place. There are a partnership agreement, a shareholders agreement, as well as any limitations on share ownership in the memorandum and articles, put and call options, because these may have an impact on inheritance tax. And depending on the type of business it is and what your will says, it depends on the powers that are given to the personal representative. The deceased, the person who's passed away, their personal representative may well have a say in the management of the business. So it's certainly something to think about, potentially appointing specific executors to deal with the business assets. Another point to mention is, have you discussed it with the family? What are the wishes? What is everyone's wishes? And your other shareholders? And on a more niche point, life insurance associated with your business interests, are they sufficient to buy out your interest from the estate? So all things to think about, but the main thing I would say is discuss with the family. What are your expectations? What are your wishes? Sorry, Paula, you're on mute again.
Thank you, Emily. It's a good job you're here to save me. The point about businesses and planning for death leads me on to the next question, which is around powers of attorney. These are documents that allow a relative or a business partner, a trusted friend, or a professional to look after either property and finances or the health of a person when they're unable to do so themselves. And with so many of us, including myself, having to take more of a role in the care of elderly relatives, I think it's brought it home to us what might be to come and the need to give more help when help is needed, particularly of planning finances and making sure all the people who are dependent can still be provided for in the event that you become unable to manage your financial affairs. We're also seeing requests for lasting powers of attorney to deal with the business affairs of a person rise, so that the business can continually be managed during the periods of illness or incapacity, so that it keeps providing an income for the family. Stuart, there are some real challenges with making and registering lasting powers of attorney at this time, aren't there?
In short, yes, there are. I do apologise if you can hear some noise on the line. My house phone has started ringing, so I hope that's not coming through too loudly on the microphone. Apologies for that. Yes, just dealing with your question, there are some very stringent rules in place regarding signing and witnessing lasting powers of attorney. Those rules haven't been relaxed despite the current crisis. Just to sort of explain the issue, basically, donors, people who are making the power of attorney and the attorneys themselves, must still sign the document with a pen. It must be in the presence of a witness. The witnesses for the donor must be someone who is not an attorney, not a replacement attorney. They must be over 18 and they must have mental capacity. Preferably, it should be someone completely independent of the donor. Witnesses for the attorney, equally, they should be over 18, have mental capacity, and can't be the donor. If there is more than one attorney and they live together, then they can actually witness each other's signatures. Attorneys can witness each other's signatures. So in the old days, I can refer to pre-COVID as that, the simplest thing to do would be to get the attorney, the donor together, and we would act as witness for all those signatures. Nowadays, it is possible for a neighbour to act as a witness on the doorstep or over the garden fence or through a window, provided everyone is complying with the government's guidance on social distancing in the similar way that Emily spoke earlier about witnessing wills. Like witnessing wills, though, witnesses must be physically present when the donor and when the attorney sign the lasting power of attorney, and signatures over video calls are not permitted. In addition to needing witnesses, you also need a certificate provider for lasting powers of attorney. And the certificate provider is an additional independent party who basically acts to confirm that the donor has mental capacity to sign the lasting power of attorney, is doing so of their own free will. No one's twisting their arm or got a gun to their head to sign the document. Who should act as the certificate provider very much depends on the donor's personal situation and who they have available. Broadly speaking, it can be someone who has known the donor for 2 years and feels happy to be able to comment on their capacity to sign the document, or it could be a professional who is an expert in the area of mental capacity law, like a doctor or a solicitor. Importantly, the certificate provider must take steps to confirm and to satisfy themselves that the donor does have capacity to sign the document and they're not being pressured to do so. Another particular challenge at the moment is that the original lasting power of attorney that needs to be signed by all the parties. As before, we'd get everyone together and they can all sign it in the same room. Nowadays, it's going to be necessary to post the document round to everyone, which is obviously causing significant delays with the postal service at the moment. Once everyone's signed, then you still need to register the lasting power of attorney with the Office of Public Guardian before it is valid, before it can be used by the attorney. The OPG were quoting a delay of about 6 to 8 weeks as standard. That is obviously now increasing due to COVID, and it's subject to their resources during this time. It probably will be longer than 8 weeks. But I think the key message is if you're thinking about making a lasting power of attorney, get the process started quickly. Line up individuals who are willing to act and able to act as witnesses and certificate provider.
Yes, thank you, Stuart. Absolutely, the message there is really we need to get on with it because there are hold-ups along the way. But having said that, there are some things that we can do while the process is going through to ease off any crises that might be happening in the person's life. Get on with it, but ask for help also. That's the end of our questions, our most commonly asked question. But we've had some questions in advance, and some of you are asking questions right now by using the little button at the bottom of your screen. I'd like to take, if I may, the first question that we had come in when we published the webinar, and that is it ever acceptable to draft your own will? And this makes me hyperventilate because the amount of homemade wills that come across my desk as a dispute practitioner is eye-watering. And usually it is because the formalities with complying, or the testator hasn't complied with the formalities that are required to make a will. But in other cases, it's just a fundamental misunderstanding of the need to give a will longevity and not to focus on specific assets. And as we said before, wills need to be constantly reviewed. And a homemade will that says, I leave my house to my eldest child and my bank account to my youngest child, could lead to incredible unfairness in the family. So the answer is, well, of course you can. Will forms are freely available on the internet, but be very, very careful because of so many of them end up in really unhappy and expensive disputes afterwards. Right, I'm just going to check on the questions and answers section. So I've got a question here from Henrietta. Hello, Henrietta, and thank you for your question. And I just need to, oh dear, that's a bit complicated. So Hannah is a financial advisor, and she is asking, Henrietta, financial advisor, trying to persuade clients to execute or to make a will at this time. Often the pushback is that the will seems so complex in terms of language used and in trust. Can we just do simple wills for family with minors where there are no divorces? Emily, if I pass that one on to you.
Absolutely. Thank you, Paula. Yes, that is something that I do come across as well on a daily basis when I meet with clients. Wills can have archaic language in them, but what we try to do is, where it is necessary to have that language within the will, we explain it thoroughly to the client in plain English, because there's nothing worse than having a document put in front of you that you don't quite understand and are not comfortable with. So explaining the language use, because in some situations it is necessary to use some legalese, but certainly for a simple will for a family with no minors and no divorce, it shouldn't be overly complex. The language used, and it really depends on the will drafter at the end of the day, what language they use when drafting their wills. But it doesn't necessarily have to be archaic language used, and so it can be quite straightforward.
Thank you for that. And Scott, thank you very much for your question, which is about your own personal circumstances. You've got around about £500,000 in assets and a business life insurance policy, and everything goes to your wife on your death. You're asking us, do you need a complex will, or would that be simple? And you're also asking a question about inheritance tax. And I guess the question you're really asking is whether you would get business property relief on your business assets. Emily, are you able to pick that one up as well?
I certainly can. Scott, there are many aspects to will drafting, and so it would have to be looked into whether there are any exemptions available to you. But generally, there are exemptions that are available to everyone. Everyone has the availability of the nil rate band, which is £325,000, which is reduced by any lifetime gifts that you have made in the last 7 years before your death. potentially a transferable nil rate band from the estate of a deceased spouse. And there's also the new residence nil rate band, or the not so new residence nil rate band now, which is where you have a property comprising your estate passing to children. Now, sometimes if everything is passed to the surviving spouse on first death, then that isn't available on first death. But when the surviving spouse dies, it can be looked into at that point, and the residence nil rate band and the transferable residence nil rate band can and may be available for you if there's property in your estate. Ultimately, it depends on the full extent of the assets that you do own. So I can't give you a yes or no answer on that, but you've got the nil rate band, £325,000, the residence nil rate band, which is £175,000, and also the transferable bands of that as well. So between a married couple, we're now looking at £1 million tax-free. Anything to do with business assets or anything like that would require a detailed discussion more than just a yes or no answer, but I hope that helps.
Yes, thank you. And I think, Scott, the answer is it can be as simple as you need it to be. But if you're looking for us to look at the holistic side of your business and your family, and make sure the children are properly provided for and that you've got longevity in planning, then it may be more complex, but it would be complex to your family's advantage in the future. I have a question here, which is very relevant to today's situation. Stuart, this one's for you. What are the implications of self-isolation for those who are living with dementia who might not appreciate the risk that the virus presents?
Thanks, Paula. Yes, a real challenge at the moment. I think that there's a good few questions actually that raises, or a good few issues that raises. I mean, can you restrain someone who is living with dementia from leaving their property if they are putting themselves and others at risk of spreading the virus? I mean, the issue there is you're looking at deprivation of liberty, which is not something that can be done really unless it's court authorised. If they have an attorney acting for them, a health and welfare attorney acting for them, then the attorney would be well advised to make sure that the local authority is aware of the situation, and even recommend that the local authority apply for a deprivation of liberty safeguarding order, which in essence means that the individual can be validly prevented from leaving their property. I mean, everyone has a right to freely live their lives and go about their lives. So certainly if there's an attorney in place, they'd be well advised to make sure the local authority has a deprivation of liberty safeguarding order in place. Looking at it, I suppose, slightly the other way round, can you stop visitors coming to someone who has or is at risk of the virus? A health and welfare attorney can certainly prevent people from visiting an individual who is self-isolating and lacks capacity. The key thing there is the individual themselves simply cannot have capacity to decide whether they want someone to come and visit them. In that situation, if the attorney is satisfied they lack the capacity, then they can validly prevent someone coming to see the individual in their home. Again, the question the attorney's got to come back to is this in the individual's best interest? And I think it more or less goes without saying that in this current environment, if they are going to place themselves at risk of contracting this virus, at risk of very serious health implications, then it comes down fairly firmly on the side of best interest. It would not be appropriate, would be appropriate for the attorney to prevent someone visiting. The other aspect that also comes to mind is care provision as well. If there is someone who is living alone, living with dementia, whose capacity is diminishing, but they are essentially able to look after themselves, my view is that it is an ideal time to be looking at getting a live-in carer, a domiciliary carer, not necessarily so much to provide care per se, to do cooking or making meals or anything like that, but more to be a companion, more to encourage the individual not to leave their property. I think the implication for health and welfare and financial attorneys there as well is to get a care assessment undertaken as soon as possible, and also to look at funding for that care. Overall, it is a changing situation. The term unprecedented has been bandied around a lot. There are a lot of challenges here that we're going to have to face. But I think where there are individuals lacking capacity, where they have attorneys or deputies acting for them, attorneys and deputies really must be stepping up their game to make sure that the individual isn't being placed at risk, isn't placing themselves at risk as well.
Yes, thank you, Stuart. And then one last quick question, which I'm going to direct to you, Stuart, also. Do we have the same issue with the witnessing of trust as we do with wills? And thank you, Kerry, for that question.
Thank you. Good question. Yes, I mean, in terms of witnessing, you're still going to need to sign the document. With trust, it can be somewhat easy. You can sign counterpart documents. So not all the parties necessarily need to sign the same document themselves. They can all print it out at home and sign their own individual counterpart. And hopefully in those situations, they will have someone in the house or living with them who can act as a witness and sign the counterpart there. So it is somewhat easier than signing wills and powers of attorney, where the same document must be signed by everyone.
Thank you very much, Stuart, and thanks to all of you for your participation. There were 50 of us at the height of our attendance today, which is brilliant. And especially thanks to our panellists for sharing their experience with us. We're going to listen to this event if you want to listen again or pass it on to a colleague or to a friend. And there are lots of other hot topics on the Irwin Mitchell Corona Hub, which you can find from the Irwin Mitchell website. And finally, if any of you have any further questions for us or have any ideas for further topics that you'd like us to cover in our webinar series, please do let us know by email to the address that's showing on your screen right now. So thank you from all of the panellists and from me for joining us, and please do stay safe and stay in touch with us all at Irwin Mitchell. Thank you very much. Goodbye.